You know that we can get pretty wound up about it. And the solution for California water is not to be found in this particular piece of legislation. Facts are difficult things to deal with, but they are facts. There's been no man-made drought. There was a very real drought, and in addition to that, there were restrictions on the pumping. Let us understand that the principal advocates of this bill have the shortest straw. They came last in line, and therefore they're not first. They're last, and their contract provided for shortage provisions for a variety of reasons, among them droughts and environmental restrictions. So they should have planned for that. Apparently they did not. The losses to the agricultural community were significant, to be sure, but at the same time, the agricultural community in the Central Valley prospered, having the best years to any previous year that occurred during this drought period. Certain farmers were shorted, no doubt about that, but they had a contract that called for those shortages. Now let us understand that this bill has profound implications on every state, some 21 states that have contracts with the Bureau of Reclamation. This bill, should it pass and become law, is a signal to every state that you cannot count on state law allocating the water within your district. Instead, it will be Congress that will allocate the water within your state. That is a profound change. 100 years of reclamation law are pushed aside by this piece of legislation. And for the state of California, it is a total preemption of state law. A total preemption of state law. And state constitution is pushed aside. There is within the California Constitution a thing called the public trust. The legislature and the government of California holds in trust for the people of California the water of California, and this legislation pushes that aside and gives that water to a very special group.
Time of the gentleman from California has expired. The gentleman from Washington.
Mr. Chairman, am I correct to